Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Sadkovich from ZFZ. How are you today, Calum?
I'm very good, Luke. How are you doing?
Not 100%. I've been feeling a little ropey, suffering a bit of a cold, but I could not resist recording today because I thought this was a super fascinating case.
Really, really interesting case. One of the most interesting of the year, I would say.
Yeah, well, you've heard the story, so I won't go on about it too much. But in many, many ways, the firm was born out of a misdelivery claim years and years ago. Ed Floyd and I, when we were at different firms, I was over on the London side and he was in New York, and we worked on a big misdelivery claim, which if I started getting into it, it would take up the rest of the podcast episode. So if you're interested in that, get in touch. I'll tell you over a drink or something one day. But yeah, so whenever there's a misdelivery judgment that comes out, and this one has only just come out, I couldn't help but notice it and say, let's do a recording as soon as we can. It came out on the 3rd of October, 2022.
And it's a sizable claim. There's a big amount at stake. There are lots of parties involved, represented by a number of very, very serious barristers in the world of maritime law. And it's a judgment by His Honour Judge Pelling Casey, sitting as a judge of the High Court. And yeah, as we all know, His Honour Judge Pelling has a phenomenal grasp of the shipping world. So this is, unsurprisingly, a very detailed, thorough, and commercially thought through judgment.
This is a case that's a must read for anyone coming into the industry, junior maritime lawyer coming in, someone sitting in ops and trying to work out what letters of indemnity are all about, why you have back-to-back charter parties, what happens when you don't keep them in a contractual chain. Huge sums involved. We've got three of the biggest players in the hydrocarbon business. We've got Trafigura, Gunvor, a subsidiary of Gunvor, Clearlake, and Petrobras, as well as a financing bank that took action in Singapore. So we've got some heavy hitting players involved. You're looking at $70 million claim, and then the additional claims for other losses run into the almost 10 million, I think, as well. So big case, really interesting case. And I say a must read, not just because of the subject matter and what's covered in this case, but also how it's set out. I really enjoyed reading the context, expressly stated as this is the context for which I'm going to look at the legal issues in this case. And the judge then goes through and sets out the maritime context. I thought it was a really nice introduction, if I may say.
It is a really nice way to introduce it. And I think specifically, if you are time poor, but you're one of the people that you were just referring to who's looking to understand how LOIs work in the maritime context, then even reading paragraphs 1 through 10 of this judgment, where His Honour Judge Pelling does exactly that. He sets out the commercial context to which LOIs exist. Is a really worthwhile, 2.5 pages worth of reading. And it goes on throughout the judgment that there is this sense throughout that the court's trying to arrive at something which is a commercially sound perspective, and taking that in itself, I was interested in your thoughts on this, Luke. Whether that represents a slight departure away from the more literalistic judgments that perhaps we've seen over the last decade or so, back towards something a little bit more commercial. I put that out to you as a question.
An astute question for not the first time, Calum, from you, but I think it's worth getting into. I really do. And Look, you reflect upon these things. We've had the privilege of reading many judgments from different judges, some that are relatively new to the bench, but have obviously got huge amounts of experience as Queen's Counsel, King's Counsel, and those that have been, whether it's at the appellant level or even at first instance level, that have been on the bench for a long time, and looking at how the judgments are written, the differences, perhaps I just got this strong sense coming through this decision was that it was being written from a very commercially sound perspective, and that's not to say that other judgments are not, but it had a strong sense from the outset that it's important to understand the issues at play here in this type of claim with the commercial context in mind. And that was perhaps in large part because of what needs to be done, some of the legal gymnastics that needs to be done in answering the questions that come up in this case. But also I thought there's a real kind of sense that if you adopt too literal approach when you're dealing with commercial parties that might not be drafting these very sophisticated contracts, but without the skills of a lawyer involved, that you do need to look at them commercially. It makes sense to look at them commercially and understand the commercial context. And I think you're right to say that this case tips more towards a commercial contextual analysis than we may have seen in some of the other more literal approaches.
The key commercial point that underscores this entire judgment is that it's completely implausible that a party in a charter party chain would agree to discharge a cargo or to deliver a cargo without either an original bill of lading or an LOI. That assumption by from the bench of effectively that just being discounted as a possibility. There's just no way that the parties intended for the contract to provide for a situation where a party was required to discharge goods without presentation of an original bill of lading or without it being against an LOI. That was just discounted from the start, and it followed from that very sensible and you could say straightforward commercial proposition, that informed the decisions that were made to an extent in this judgment.
What are we talking about here, Calum? Like just stripping it back, if we go to the introduction that is set out here, and I think it might be useful to start there and talk about what are letters of indemnity. What are we dealing with? Well, in these types of cases, we have a vessel has cargo on board. It's issued a bill of lading to the shipper of the goods. The bill of lading itself is a document of title. Whoever's holding that bill of lading has title to the goods and has a really important central function to all of this type of shipment by sea. Of course, the bill of lading has other functions as well. I won't get into those now, but holding the bill of lading gives you title, and the bill of lading is what is then transferred through the sail chain, so the cargo chain, to the other end, and in theory, the receiver turns up, having paid for the goods. They've gotten the original bill of lading as a document of title. They then take that bill of lading and hand it over to the ship to get their goods. So the actual original document is exchanged for the goods. That's what happens that's what should happen, I suppose. It's not what happens in reality because, as we know, particularly in the oil trade and hydrocarbon trade, ships move very quickly. The ship gets to the other end, and lo and behold, the bill of lading hasn't arrived. So this practice has developed over time to get around this issue of needing to present original bills of lading to get delivery of the cargo, and that's the letter of indemnity. So the letter of indemnity is provided by a party saying, look, we will indemnify you, ship owner, for any risk that there may be in delivering the cargo to the receiver without delivery of the original bills. Now, the bill of lading, it serves not just as security for the actual receiver, but it also serves as security for any financing bank along the way. And so if you have a bill of lading passing through the sale chain, it may well be, and is often the case, particularly when we're talking about $70 million for the cargo value, that the actual receiver, the actual buyer of the goods, is not funding the purchase out of their own pocket. They're using the finance of a trade finance bank, and that bank gets hold of the bill of lading. They are the proper holder. They hold the document of title until such time as their borrower, so the actual buyer, sells on the cargo and makes a profit, and the funds are then paid off to the bank, or they otherwise pay the bank through some other mechanism. And so the bank often is in a position of holding that bill of lading. If for whatever reason their borrower doesn't pay them, or the on sale falls through, they have the security. They have the document of title represented by the bill of lading, and they can go and assert a claim against the owner for possession of the goods. And so what happened here was that there was letters of indemnity. Well, there are indemnities built into the original charter parties, which we'll get into in a minute, and I'll hand over to you, Calum, to talk about those. But there were indemnities in place that allowed for these goods to be delivered to a receiver. The bill of lading had not made it through to the receiver. They were stuck with one of the financing banks. Goods delivered notwithstanding, against what the parties understood there to be indemnities in place. Then the actual bank holding the bill of lading, turns up and says, well, hang on, I'm not happy with you delivering the goods over to these cargo interests. I still have hold of the bill of lading. They then go arrest the ship and say, you've misdelivered the cargo to someone else who's not the proper holder of the goods. And then the ship owner turns to the parties that have indemnified it, so through the charter chain, so looking down to the charterers and then to the sub-charterers. And there's some complication in the charter chain here. But they look down for an indemnity. One, to put up security because the ship's now arrested. Two, to get the arrest expenses paid. Three, they had the vessel on a charter, the P66 charter, and it was being positioned to then have a follow-on charter. So they lost those charters. The ship owners had to pull out of them, or at least the disponent owners in the charter chain. And then you had this claim being brought for the value of the goods, the $70 million for the actual value for the misdelivery by the bank against the carrier under the bill of lading. And we're now dealing with issues arising in those indemnities. Were those indemnities properly written into the charter party? Were they binding? Were the right parties involved in giving the indemnities? And it gets really, really messy, and from a lawyer's perspective, interesting in that respect.
Exactly that. That's a very, very good summary of exactly how this whole thing was unfolding, and exactly the issues that were arising between the parties. And the first question the court had to answer was the extent to which these charter parties included indemnities. In the instance where the owner in each charter party was requested by the charterer to discharge, just notwithstanding the fact that there was no presentation of an original bill of lading. And the owners in each case said that there was an indemnity given by the charterers when they made that order under clause 33(6) of each of the charter parties. And the charter parties for this part of the dispute, I say this part of the dispute, it actually went on up the chain. We were only interested in the chain as high up as Trafigura, but above Trafigura there were head owners who also had a claim against Trafigura, but there was a difference in the arbitration or the jurisdiction of the indemnities that were dealt with by the court, and the indemnity that was dealt with under that claim against the head owners. So that was dealt with in arbitration in Singapore. But as far as we're concerned, there were two charter parties on materially identical terms. For now, we will talk about there being owners, disponent owners, and charterers, but actually disponent owners covers a slightly woolly relationship between the two Gunvor entities, so the two Clearlake entities. And the question was, in each case, in each of these charter parties, was there a indemnity given in circumstances where the charterer requests delivery without presentation of bills of lading? And the owners in each case said this was dealt with under clause 33.6, which said that if charterers request owners to discharge a quantity of cargo either without bills of lading and or at a discharge place other than that named in the bill of lading and or that is different from the bill of lading quantity, then owners shall discharge such cargo in accordance with charterers' instructions in consideration of receiving an LOI as per owners' P&I Club wording to be submitted to charterers before lifting the subs. It then said, following indemnity deemed to be given by charterers on each and every such occasion. And charterers said that on a proper construction of this wording, they had not given any indemnity. And when owners were discharging the cargo, owners were doing so without the benefit of an indemnity. And this was the argument that commercially the court really disliked. The court said there's no way that owners would have been giving the cargo up to a party who have not presented a bill of lading without an indemnity. So if it was the case, and we can get into the construction arguments around this, the arguments that owners were put forward, but if it was the case that on a proper construction of the charter party, owners did not have an indemnity, then the effect would not be that there would be delivery without an indemnity. The effect would be that owners would be entitled to simply refuse to deliver until they received the original bill of lading. And in the meantime, they could have claimed demurrage under the voyage charter.
And look, I think it's important to kind of make this point at the outset. We've already been talking for however long it has. But, and I'm not sure this was completely explained in terms of the history in the judgment. But once upon a time, there was no such thing as indemnities for delivery without bills being written into the charter party. And I think that's an important point to note, because if there was none of this language, right, if there was no language written in there about delivery without presentation of bills against an indemnity, what would have happened? Well, what would have happened was the owner would not have been obliged to deliver the cargo without the presentation of original bills. And then what would have happened is, after the contract's in place, at the time of standoff at the discharging port, the charterer would have come to the owner and said, well, the bills haven't arrived. We haven't got the original bills. We want you to discharge. We'll offer you a letter of indemnity. And then the indemnity would be put in place, signed, sealed, delivered, all of that, just prior to then going ahead and delivering the cargo after the contract's in place, right? Now, what has happened for efficiency and for, in certain trades where this is very common, that rather than wait until you're at the discharge port where you're dealing with an uncontractual situation, owners are being asked to do something that's not provided for in the contract, so therefore they get the indemnity, which leaves it all for negotiation on the terms of what that indemnity would be. It's now very commonly written into the charter party at the outset to say, if the original bills are not there, then you need to deliver against an indemnity. And so it then gets brought forward, if you like, as a contractual term. And I've always thought it curious, with such an important point like this, that the letter of indemnity or the full wording of the indemnity is not then written into the charter party. It's often this kind of reference by incorporation, as we saw here. And there's an additional problem here, because the wording, as Calum just mentioned, talks about the IG, which is the standard letter of indemnity wording that's published by the IG, the International Group of P&I Clubs, that here was supposed to be provided before lifting of the subjects on the contract. So before the contract became unconditional, It wasn't done. And so what does that mean? You've got a clause that purports to incorporate language of a standard form indemnity and that it needs to be provided before fixing, but it wasn't provided. Now what do you eat? And there's an answer to that, and the judge eventually comes up with an answer, which I think makes sense. But let's come on to the decision in a moment. But what I'm trying to say is there's a real, unprofessionalism to the way that the drafting has been dealt with by the industry, I think, around this really important change in eroding the function of a bill of lading by incorporating this indemnity language. And it's just not dealt with well by the contracts, as we saw here.
There are two things with LOIs that they come up time and time again. We see them often, and the first one is the one that you mentioned. How clearly is your LOI incorporated into your agreement? Is it completely clear what terms the indemnity is going to be on when you're delivering as an owner, or when you're seeking delivery as a charterer to a person without presenting original bills? That's the first question. That's what comes up here, and it causes ultimately owners are okay, and they are found that there is the LOI is incorporated. So there's some comfort there that suboptimal wording can still get you to a position where you have some degree of comfort. I think that's the right decision. I think that probably is what the parties had agreed. The second point, which is mentioned again in the introduction, is that the LOI is not really a particularly attractive replacement for a bill of lading, because a bill of lading gives you title to the goods, and that gives you some kind of security. You have some security stronger than just your counterparty's creditworthiness. Whereas an LOI is a separate contract, and there's case law on this outside of the decision we're discussing today, which is the Miracle Hope. But there's case law outside of the Miracle Hope, which makes it very clear that the LOI is a contract which sits outside of the charter party, outside of the bill of lading. And if you want to claim under an indemnity, then you only have a claim. So you have to, as the parties did here, go out and try and get security some other way to support your LOI claim. Whereas the bill itself gives you that security, because you have you have the right to the cargo, or if you're the owner, you have the right to discharge. You know that you're discharging to the right person if they're presenting a bill. So there are issues with the ways that LOIs are incorporated in common commerce. I suppose you could say in this case, there's not going to be a huge number of issues around creditworthiness. The companies are so large that that's not a concern. But maybe in the bulk trade, for example, there are a number of parties who are involved who are might be, it's a kind of one ship company, or it's a chartering outfit rather than an ownership outfit, and you can't be certain that the company that you're getting an LOI from, or I should put it differently, if you can't be certain that the company that you are contracting to provide you with an LOI in circumstances when you're taking on a big potential liability by delivering to somebody who you don't know for sure that the person you're delivering to is the correct person to be delivering the cargo to. In those situations, you're taking on a big risk against an indemnity from a party that you should be pretty confident is able to repay you in the event that you end up, doing something wrong and taking on that liability.
I've lost track of the number of times that over the years I've had to explain the significance and scale of the risk that's being adopted in using LOIs. It amazes me that, and you're right, like in this scenario, we're dealing with some of the biggest players in the market, and creditworthiness is probably not front and center in terms of the main considerations here. And it's why in this trade, particularly in the hydrocarbon trade, for the vast majority of trades, it's done commonly and it's not an issue. But as you say, once you start creating a different way of working, and you take away the function of the bill of lading as a document of title and replace it with an indemnity, you're dealing with a different scenario. And in the bulk trade, for example, a lot of, even some of the bigger names in the bulk trade, they're working on fine margins. Well, they've been making pretty good margins recently, but they're not covering the full cargo value themselves. It's not, they don't have the cash sitting around for the full cargo value. It's being financed invariably. And even some names, and the case that we were involved in, it's going back 12 years ago now, the charterer was a well-known Swiss trader at the time. And they had a credit crunch and what have you, and ultimately the case worked out. In the end, we got security. But it's not like they had a huge amount of cash on hand to pay out. And as the judge says in this case, a letter of indemnity is unsecured. It's only as good as the financial status of the party issuing it. That's it. You've just got a claim. Nothing more. And you've then got the additional hurdle of enforcing that claim and getting security yourself for that claim. And as we know, getting security under an indemnity is not easy to do. Anyway, look, it's a super important point. It's one of the reasons why we're seeing more moves in the market to electronic bills of lading, which will hopefully reduce the need for indemnities and other factors. But for present purposes, this is a critical term. I tend to think that there should be more work done. And yes, I would say, because I'm a lawyer, but consulting with your lawyers, your in-house department, your external lawyers, for those out there who fix charter parties on, is the language in our charter party sufficient to deal with the indemnities? Is our practice of using different, as we saw here on at the Clearlake level, the practice which we see regularly in the industry of chartering in with one entity, chartering out with a different entity in the same group, is that a sensible way of proceeding? When you're dealing with indemnities, what happens when there's this break between two entities in the indemnities? Is there an internal indemnity between the two intra entities? So, look, many issues to get into. How about we kind of drill down on some of the specifics? In this case, Calum, would you like to kick that off?
Yeah, let's kick off with the construction around that wording that we discussed earlier. So the wording says, owners shall discharge the cargo in accordance with charter's instructions in consideration of receiving an LOI as per owner's P&I Club wording to be submitted to charterers before lifting the subs, following indemnity deemed to be given by charterers on each and every such occasion. And the issue is the LOI was not submitted to charterers before lifting the subs in either charter party. And the charterers then said, well, that means that there's no indemnity. You can't rely on an indemnity because we haven't agreed one. And the owners said, no, there is, for all the reasons, around the proper construction of contracts in English law, this should be constructed as meaning that the IG group P&I Club wording, which was the owner's P&I Club wording, should be deemed to be incorporated, and it should follow that wording applies to on each and every occasion that we're asked to discharge without the presentation of the original bill of lading. And ultimately, the court sided with owners on this. And to me, that was in part it was due to a kind of literal construction of the clause and the most likely objective intention of the parties, based on the pure reading of the clause, but it was also largely informed by the commercial considerations that we've already outlined earlier on in our discussion. The key one being that it's just so unthinkable that a party would agree to discharge cargo without presentation of a bill of lading or an LOI, and that commercial, that commercial fact was just weighed so heavily on the judge's decision. Correctly, I would say it's just unthinkable that a party would discharge this quantity, $70 odd million worth of cargo to someone who they didn't know was the actual intended receiver or the intended holder of the bill of lading without having the benefit of an indemnity. And there were some other points around this, and some interesting legal points are in there too around construction. There's actually, I would say, at paragraph 27 is a very helpful, page rundown of the principles of construction under English law for anyone who has to, revisit those for the purposes of writing an opinion. You can crib a lot from paragraph 27 of this judgment, and ultimately, what the judge said was that you could basically delete part of the wording. It was kind of surplusage, and really what the clause meant was that owners shall discharge the cargo in accordance with charter's instructions in consideration of receiving an LOI as per charter's P&I Club wording, and that indemnity was deemed to be given by charters on each and every occasion that they delivered the cargo. There were even some arguments raised. And this is where I think it got a bit tenuous. There are some arguments raised around the fact that in the clause, it referred to the LOI as per owner's P&I Club wording, and then went on to say, following indemnity deemed to be given by charters on each and every such occasion. And they said, well, the following an indemnity is a reference to an indemnity further down the clause that's being struck through. And the judge, quite rightly and very sensibly, in my view, said, no, where they're referring to following indemnity, really they're referring to the indemnity that they've mentioned in this clause. So to kind of cut across that construction question on a objective view, based on the position of the parties at the time of contracting, the court held that there was a deemed indemnity on IG P&I Club wording each time there was an order to discharge without the bill of lading.
Yeah, I don't have all that much to add on that. I think it's a really good summary, Calum. It all turned on, it all relied on the wording following indemnity deemed to be given by charterers on each and every such occasion. And the problem, or the difficulty, I suppose, is that the word following referred to indemnity language that had then been struck out within the clause. But there was the reference to the IG indemnity language immediately preceding that sentence that I just read out. And so if you linguistically look at what following means and then it's been struck out, it's like, well, should this fall away? But the effect, I suppose, or the important part here is that the parties did insert bespoke language saying that there's an indemnity to be given by charterers on each and every such occasion. So that has to have some force, and if you don't give it the meaning that the court did here, and that is that the indemnity is a reference to the IG wording that was referred to above by incorporation, then you end up in absurd situations, a situation that somehow the owners could be obliged to discharge without original bills and without an indemnity. It just doesn't make sense commercially.
Or even that the owners could hold on to the cargo and could say,
exactly.
We're just not going to discharge, we're going to wait.
So look, I think that's a good summary of that point. What was the next issue? I'm just getting to the judgment.
There were a series of kind of sub issues around that point, but fundamentally, the next kind of big issue was this lacuna issue. Right.
Okay. Yeah. Well, let's move on to that. But yeah, you're right. There was issues around the discharge orders, the meaning of them. Was the indemnity not given? Was the condition precedent? But yeah, I think you're right. That if you're interested in that, dig into it. But that's the main takeaway from the construction issue was that there's this strong sense of what is the commercial intention here, and it was very hard, really, for I think the charterers to maintain a straight face and argue otherwise from a commercial perspective. And look, the judge did say, well, we have to deal with the words that are here. Let's look at them and give them meaning, and then from there look at the commercial purpose. So Okay, let's move on to the contractual lacuna issue. And if I could just set the parameters of this, it goes to what I was referring to earlier, where initially there was the disponent owners, Trafigura, then the charter is under that, an entity, one of the Clearlake entities, CUSA, which was the charterer with Trafigura, and then under that was one of the Petrobras entities, PBSA, Petrobras, I think, SA, and that was the sub charter fixture that we were dealing with. Then what happens at some point is that CUSA kind of, they call it an amendment in argument, but effectively it's a novation. Novates its rights and obligations under the charter with Trafigura to another Clearlake entity, CSPL. And this was actually in keeping with how Clearlake regularly set up its deals, where one of the entities would handle the chartering in, so CSPL would handle the chartering in, and then CUSA would handle the chartering out. And this is not uncommon in the industry, where an ship operator might have different entities handling chartering out and chartering in, as we saw here. And the practice at Clearlake was that this invariably happened. They, I think, cited 13 examples of this kind of arrangement, chartering in, chartering out with different entities within the last 2 months before this trade. And so that was usually how it was done. But here, actually, the charters were in a straight line. They were a straight line through CUSA. And then afterwards, come the time of the indemnities, CSPL steps in. Again, not really novated in an orderly way. We're talking about emails between Trafigura, CUSA, and CSPL, where there was this kind of tripartite agreement, I suppose, that CSPL would then step in as the new charterer instead of CUSA vis-a-vis Trafi. But what that created, right, was a novation, so that you have the contractual chain of Trafigura and CSPL, the now new charterer, and CUSA as the disponent owner to PBSA as the sub-charterer. And you had a lacuna between CSPL and CUSA, the original charterer, which is now the disponent owner with PBSA. So what was the relationship between these two affiliated Clearlake Gunvor entities? There wasn't an express agreement between them at the time. There wasn't an express charter between CSPL and CUSA. And so this was the lacuna. And because you then had indemnities, an indemnity given by CSPL to Trafigura, and then an indemnity given by PBSA to CUSA. And there was this gap. There was like this, indemnities flowing from here. And what was the relationship between CUSA and CSPL?
Exactly. And the reason it mattered is that at the bottom of the chain, Petrobras were saying, well, we can indemnify you irrespective of your loss, but you've not lost anything because you're not liable. You as CUSA aren't liable to CSPL. So the loss is actually stopped at CSPL. You're not liable to them at all because there's no relationship under which you have liability. And therefore you can pass on your loss to us, but your loss is zero. And that is I liked a lot. Trying to find it. Yeah. The way that His Honour Judge Pelling put it, where he said, this outcome has the effect of conferring a $85 million windfall benefit on Petrobras at the expense of the Clearlake Group, a result that Clearlake characterizes as commercially absurd I accept that this is not an outcome that PBSA or the Clearlake parties could have intended, and thus the point now taken by PBSA is both technical and opportunistic. The question that remains, and the only one that matters, is whether it is correct.
Yeah, I like that. I had a wry smile with that. And if I was reading this judgment through from start to finish, and I was sitting as lawyer for Gunvor or Clearlake, I'd be like, oh dear, where is this headed? Like, where is this headed?
And the thing, I had a case at my previous firm, and it was ultimately all resolved after I left, and it was resolved. I think it was resolved commercially in a large part, but it had a similar structure, and there was a party in the middle, and there was it was an ICA claim, and there was a party in the middle. That was it was a large shipping group, and the party in the middle chartered in through one entity and chartered out through another entity. And we never knew what the internal charter arrangement was between those two entities. And we didn't really want to ask it, too early on, because if they tried, if they had more time from an early standpoint, they had more time to, resolve any problems that might be there, then it was better for us if they didn't realize that those problems existed until slightly later, and then any attempt to make it actually work would have been much harder for them to do. But the other point that mattered in that charter party chain, and this is a genuine potential issue for parties who have this structure where they charter in, charter out. If you're back to back on certain charters, and in the case I was referring to, like I say, it all fell through the ICA, and often under the ICA contract, loss will be apportioned on a 50-50 basis. And if loss is being apportioned on a 50-50 basis through an ICA charter party chain, then say the total loss is 100 million for ease of maths, then that 100 million is divided between the top two parties in the chain, where there's the first ICA contract, 50 million, 50 million. And the charterer in that top charter party chain, when they pass it on as disponent owners to their next charterer, they then split the loss 25-25. And it then gets passed down and it gets split 12.5. And the remaining bit gets split each time. So if you're sat at the bottom of a charter party chain and above you there's an arrangement as there was here, but you're looking at an ICA claim, if the two parties have an ICA agreement in their kind of notional or assumed or even papered contract, which to make it back to back with the parties above, then actually there may be a situation where the parties, where a certain amount of loss rests with each of the parties in that internal structure. If they've said we pass on the head contract back to back internally, then actually they have to also apportion the ICA claim 50-50 internally. Does that make sense?
It does make sense. Number one, that is a very big ICA claim for 100 million.
But it was certainly in the tens of millions.
Okay, all right. I'm stirring. But yeah, I see that. I see that because what is the actual arrangement other than an internal charter, really?
Exactly. It must be.
It must be to make sense of it all, to pass things through, to be able to pass on losses and pass on, either that or...
Even more fundamentally, to be able to charter out at the other end.
Well, exactly. What are you chartering? Right?
Exactly. You have to... The chartering entity has to be able to charter out.
Yeah. Well, exactly. So I've wondered this a number of times along the way. It doesn't come up all that often in cases, but it's pretty fundamental, I think, and really goes to this practice of trying to separate different entities and obligations and what have you. But I've often thought that having different entities doing the chartering in and chartering out is almost a bit too cute. And opens yourself up to issues that we saw here. So, look, we could go into the details and talk for another half an hour on this topic, I'm sure. What the judge ultimately found here, and I'm really interested in what you think of this as an outcome, Calum. Talking about things that might be a little cute, is that on the evidence of how Clearlake operated and the understanding internally at Clearlake, and how, I suppose, commercial context operates in this industry, that there was an internal indemnity between CSPL and CUSA, such that when the indemnities were given up the chain, there was also an internal indemnity given between CUSA and CPSL. So you had a chain of indemnities, starting from PBSA, Petrobras at the bottom, going to CUSA, one of the Gunvor entities, then an internal indemnity going to the other Gunvor entity, CSPL, and then the other indemnity that was in the charter party with Trafigura that had been novated to CSPL. That was the decision, that there was this internal indemnity, not written, not expressed anywhere, just by virtue of the way things are done, as far as I can see.
I don't know, to be honest. I don't.
I know. I kind of feel the same. It's like, yes, it makes a lot of sense. Yes, it's pragmatic. Yes, it's probably the right answer. Like, it would be amazing for this to fall on Gunvor, but still, right?
It has to be right in the circumstances.
It has to be right. I know it has to be right, but still. He so invitingly put it, like, it makes absolutely no sense for this not to be the right answer. But is it correct? And but is it correct? I still pose that question here.
Honestly, my view is it's not correct. I think they messed up, and the problem is it's a pretty minor way to mess up, with an unbelievably large cost attached to it in one of the most uncommercial ways you could possibly hope to imagine. There's part of me that says that surely the courts have to be trying to give effect to what people intend to happen in these things, and that's kind of where this judgment goes. But you're then battling against the weight of authorities around implied terms, implied indemnities, all of these issues, and it becomes very difficult. Not because I think that it's wrong, and I'm not sure I do think it's wrong. I think it probably is the right answer. But I would just love to see this point appealed in isolation, so that we can get another kind of 20-page judgment on this precise point, really, really, supplementing this judgment. Because I would like to, I'd like to see it through another pair of eyes. I'm not sure you get the same answer.
I think there's something in it to argue. I don't think it necessarily gets turned over. It's not like that at all. And as we've said, commercially, it's the right answer. Legally, I'm on the fence. I really am. If anything, I lean towards this not being correct. And I say that from the perspective of implied terms, and as you mentioned, what I think what they were asking to be done here was an implication of an indemnity. Why is that being implied? Where should that be implied? Where is this internal charter party to imply it into? And when you come back to where we started in all this. These are such important things to get right? Why is it that the law should be providing an answer on such a fundamental change to the way a bill of lading works in a kind of, well, this is how it should be type of situation? Like, isn't there something to be said? This is such an important process we're going through. If you want to agree an indemnity up front, it should be written in your charter party. You should have a written charter party, It's kind of, and it's not just that. It wasn't, in this situation, it wasn't even just that this was how they always did it, but they had to novate halfway through as well. Like, they then had to rearrange things halfway through the situation. Why wasn't it sorted out at the time of novation, or some point taken at that stage? It just strikes me like there's some roughness to the way this is done. And I mean that with the greatest respect and all the rest of it. But, we're just looking at this case based on what we see in front of us. And it feels like the law is being stretched and pulled to come to the right answer here. And should it really be that flexible? I don't know. I really don't know.
I completely see where you're coming from on it. We bemoan it from time to time, right? When you look at these judgments, and it's why litigation lawyers will often advise their clients, avoid the dispute, because you're going to get a binary outcome, and the binary outcome is not always one that's going to be, in line with what you expect commercially to be the case. And it's why so many maritime disputes do settle before they go anywhere near a court. On the one hand, I think that it's really important in a world with a number of different jurisdictions that are very sophisticated, that offer a very good service to a number of different across the maritime industry, for the court to be as commercially savvy as it is here, as it has been with a few decisions. Really, I remember James Depiche on one of our previous episodes mentioned that he really saw that in the English court decision, where they were looking at the arbitration agreement, whether it was formed or not, and whether it was purely a contractual question, or whether it was a slightly quasi-contractual relationship, and the appointment happened at some point before all the terms were agreed. And he said that in that decision, he was struck by how commercially minded the court was, and how deep their understanding was of the industry that they were discussing. And I think that's a really important thing that the court has, and that's something that's reflected in this judgment: a really, really complete understanding of the commercial subject matter rather than just the legal subject matter. So on the one hand, you have that massive, massive positive. On the other hand, you have this, sometimes the certainty of law is brutal, and it puts you in a position where you inadvertently carry the can for $85 million worth of damage because you failed to pay for an internal charge party. But is that wrong in circumstances where it is what a proper application of law gets you?
Can I pose it a different way, right? Why in the first place is there a practice of having different entities chartering in, chartering out? Why?
Yeah, it's liability.
It's liability. So there's some reason for this structure. There's some reason for putting in place a structure where you have separate entities chartering in, chartering out, presumably to try and shield liabilities if that were to arise in certain circumstances. If parties are going to go to the step of trying to benefit from the corporate veil, right, and they put in a structure and they don't then properly paper the contracts between them, why should it be stretched in their favour? Like I really struggle with that.
If we stop thinking about them as the Clearlake entities and we think about them as two separate companies,
that's what they set up. That's what they set up, right?
Yeah, no, I agree.
That's what they set up.
Yeah.
They didn't set up. Oh, you're dealing with both of us, just with different hats. They set up two separate entities.
It's very true, and you can guarantee if the shoe is on the other foot, and someone was trying to say these are actually the same entity, and there's a bunch of implied relationships between them, then they would be saying the opposite. They'd be saying no, they're two separate entities, two separate profit centers, two separate this and that, separate directors, numbers, all the separate books, all the rest of it. I completely take that point. They would be very happy to take the benefit of that structure.
Well, I don't see what else it achieves. Why else have these separate entities? Anyway, look, we're getting off point. We're fully into commentary here. This is our own personal views on things, just as we see it on the judgment. But there's room for argument. I really that's what I think it boils down to. It won't surprise me at all to see this appealed on this point. I think the construction answers from my own perspective, with respect and all the rest of it, I think is the right outcome. I couldn't see that any other way. I'm not as convinced on this internal indemnity point, but we will see. We'll see. It does make a lot of sense, and maybe the parties decide to accept it and move on. There was just one final point I thought to mention on quantum. So basically, the owners, and it was a it went both ways. So Trafigura against Clearlake won, and then Clearlake against Petrobras won, and meaning that they could claim under the indemnities. The indemnities were binding; they were in place. There was this internal indemnity between the two Clearlake entities, so you had a chain of indemnities running through. The question then was what could be recovered under it. Obviously, they could recover the value of the cargo, but there were these consequential losses. So there was the P66 fixture, which Trafigura had in place, and because the vessel got arrested by the financing bank in Singapore, they couldn't perform that fixture. It fell away. But that fixture was, and so that fixture, the losses, the profit was claimable, and the charterers tried to argue that it should be limited to the time, so the loss of profit element of the P66 fixture should be limited to the time during which the vessel was under arrest and cut off at that period. The court said no, it should be the full profit under that whole fixture, even if it went beyond the time of the arrest. But what the real area of debate was actually not on that, I think, even though that point was taken. It was on the follow-on fixture. So after the P66 fixture, the vessel then would have been in a very, very favourable place to then earn more profit, and they had a fixture lined up. That fixture, the loss of profit element in respect to the follow-on fixture, was not recoverable, really because it would have involved too many uncertainties in trying to price what that quantum was. It would have involved looking at where the vessel would have ended up, what other costs and profit would have had to be brought into the equation at that time, what the market was doing. There was a whole lot of vagaries associated with it that made it too uncertain. It was it was not in the exceptional category that Males was referring to in that prior decision. Yeah, in the MTM Hong Kong decision and the Null Bay, essentially the measure is to look at what you can see, that's the prima facie measure. And Males J in that decision talked about where it becomes too uncertain, where it becomes too remote. That's no longer recoverable. However, there are some cases where a follow-on fixture may not be considered to be too remote, and that's the exception. And ultimately, here, Pelling sitting as justice in this decision decided that the follow-on fixture was not an exceptional case. It was one that was too uncertain, and thus it was not recoverable. And there's some other discussion about arrest expenses in there as well. But look, that's I think the summary. I don't know if I could call it a summary or the unpacking of it. As I said at the outset, it's a really enjoyable case if you're working in this area of law or getting involved in this area of law or want to know about maritime law. It's a fascinating case. I won't be surprised if it's not the last we've heard of it, but we shall see.
It was a really good one. Really enjoyed talking it through actually with you, this one.
Thanks, Calum. As always, it's a pleasure. And for all our listeners, if you've made it this far, thank you. We hope you've enjoyed the discussion. Please do subscribe to our podcast. It certainly helps us gain traction on the various platforms. We're obviously on YouTube now if you're watching this, or if you're listening in on Spotify, Apple, or Google. Click subscribe. Feel free to share this in your networks and with your team members at work. And thanks again. Until next time, take care.